Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney. And today I'd like to talk to you about how far back you need to go when submitting medical records to Social Security for your disability case. And there are really two answers to this question. First answer is, as a practical matter, what the judge, if you get to a hearing, is going to be most concerned about are the, let's say, 2 to 3 year time period before your alleged onset date. So let's say you allege you became disabled in September of 2015. You may want to go back to 2012, 2013, and get any records going forward from that date. Because if you were still working, assuming you're still working in 2012, 2013, then whatever medical records you had would suggest that your condition was not at a serious enough level to disable you. But it does show some history and some continuity in your treatment. So I would tell you that even if you were working and there are medical records that talk about the condition that eventually became disabling, go back 2 or 3 years. I would also tell you that if your condition is one that is lifelong or that started much earlier, go back as far as you have to go back. I recently had a case involving multiple sclerosis, and my client first started noticing symptoms back in the 1990s, and our hearing was in 2016. So I had medical records going back to 1995. And again, that just showed the progression of the disease. Sometimes in mental health cases, it could go back to childhood. So we may get records from elementary school. Other cases, for example, depression, may be something where somebody had a hospitalization 10 or 15 years ago. So in some cases, you want to go back even further than 2 or 3 years. It just depends on what the condition is and how germane those medical records might be to a judge understanding what's going on now. I would tell you as a general rule that continuity of treatment, long-standing treatment, is a positive thing for Social Security judges. They recognize that someone who's been treating for a condition for 15 or 20 years, that indicates that that condition is severe, and obviously if it's getting worse over time, that time record will be very, very relevant. So I think, again, as far back as you have to go, and if you have to default to anything, go back as far as you have to, as you possibly can. Now, you'll find, of course, if you're going back 10 years, 15 years, it can be difficult to find those records. Many times hospitals or doctors' offices close, they merge, the addresses change, so you may have to do some detective work to try to track down those records. You may have your own records. And of course, it's always a good idea to get your medical records, but you may have some that you have to submit. Sometimes one medical record will reference another one that's not actually there. So for example, you may have a record dating back 5 or 6 years that references an MRI report. The MRI report may not actually be available, but the record from 5 years ago references it, and since Social Security uses a relaxed standard of evidence, that can be evidence that you can use to help support your claim for disability. So big picture is get whatever you can possibly get, submit it. If Social Security doesn't want it, they don't need it, they can ignore it. But what you don't want to find yourself in is a situation where the judge wants to see some records that reference something that happened 10 years ago, and you just thought, well, it's not a big deal, nobody will care, and never got it. And that could be the difference between winning and losing. So never assume anything. Don't assume that you know what Social Security wants. It's always better to have too much than too little. And of course, at the initial and reconsideration stages, they'll request them. Social Security will request them and pay for them. So they'll do the heavy lifting there. After you request a hearing, it's you and your attorney have to do it. But again, if it means the difference between winning and losing, and again, sometimes, for example, school records can be a big difference, then you have to get those. So anyway, I hope you found this helpful. If you did, please give it a thumbs up on YouTube and a like on Facebook. Subscribe to our YouTube channel. And if you have any questions for me about the disability process, please reach out to me directly. I'd be happy to try to answer your questions and help you any way I can. Again, I'm Jonathan Ginsberg, and I'll see you in the next video. Thanks a lot.